Right, let's into this now. The Gauteng High Court has denied an application by a group of illegal immigrants who were detained at the Modderbee Correctional Services Center in Benoni. The group wanted to interdict Minister of Home Affairs and other respondents from detaining, prosecuting and deporting them until their status has been lawfully and finally determined. Minister Motsoaledi joins us now for more on that. Minister, good evening and thank you very much for your time and for coming on this evening. So these six, is it six? I think it is. Thomas Godiso, Abi Osman Yusuf and four others. Are these Ethiopian nationals or they come from various other countries?
Good evening, Tabo. Good evening to the listeners and viewers. Ethiopians and Somalians, Tabo. Only two nationalities. Right.
Ethiopians and Somalians. And when did they come into the country and how long have they been evading the authorities?
Well, they came at different times, but they were arrested last year. It is not very clear to me yet at what stage did they enter. I think that will occur when they are interviewed, because in the court papers it does not show.
And what has kept them from going the legal route and applying for proper asylum?
Well, many illegal people do not, Tabo, and I've made this point many times. Whenever people make noise about Home Affairs documenting people, I made this statement and I want to repeat it. When a person visits a refugee reception center, and we have got 5 of them in the country, Musina, and the biggest one, Desmond Tutu Refugee Reception Center in Tshwane, in Marabastad. We have got one in Cape Town, we have got one in Tebeha, and the other in Italy. If you arrive on any one of those, you are bound to be documented because they will give you a Section 22 permit under the Refugee Act, which gives you permission to stay in the country for a period of 3 to 6 months while you are applying for asylum. And that document is renewable depending on how far is the processing of your status in the country. Now, many people do not do that. They just stay in the country. And when they are arrested, is then that they say they want to apply for asylum. They are doing this because of a judgment made by the Constitutional Court, which was delivered by Judge Cameron in 2018, where, citing Section 2 of the Refugee Act, declared that if anybody is arrested, regardless of how long they've been underground, once they declare that they want to apply for asylum, then they must be released. The Constitutional Court, through Judge Maya, have subsequently somehow amended that by saying, yes, you can apply for asylum, but you must give good cause. In terms of Section 31, Article 31 of the United Nations Convention of 1951, you must give good cause why you entered the country illegally, why you stayed so long, what stopped you from going through a port of entry and asking for asylum. And that's the gist of this judgment, that people must give good cause, and it's in line with an international convention. So, this is something that has not been used in the past, and has been overlooked by the courts in the past.
So an expression of intention to apply for asylum seeker, you're saying, that, according to this particular judgment now, means it does not trigger the protections of Section 2, like immediately without, of course, giving good cause.
Yes, and Section 2, let me explain that because people might not know what Section 2 is. Section 2 is extremely problematic. If you look at the white paper on immigration, when we said we want to repeal the laws, one of the laws we are targeting is Section 2 because it causes problems. Because the manner in which it has been enacted has actually been very erratic and impractical. So people just quote it. Now the judgment is saying Section 2 will only kick in after you have given good cause. Good cause meaning, why are you here illegally? Why did you jump a fence and not come through the normal gate of entry? What are the situation and circumstances? You have got to give satisfactory answers. Only then can Section 2 kick in, where you are now going to apply for asylum and Section 2 protects you. That's basically the gist of this judgment.
And does this empower you then, therefore, and your officials in particular at immigration to deal with the issue of illegal entry and people wanting to stay in the country?
Of course, it does help because people no longer have a leeway just to stay put, not go to any center and say any time they arrest me, I'll just tell them I'm applying for asylum, which is what happened in the Constitutional Court case in 2018. Now they know that space is no longer like that. They've got to give good reasons, so it does help us.
Now, you know, the last time with the COVID-19 and of course being in a state of emergency, there were laws that were introduced on a weekly basis, and we were always told that the ministers will come afterwards and give us regulations as to what actually this means and how it will be implemented. Do we have regulations on what good cause would be? That would be a guide, I suppose, for the department in terms of what would be the grounds for you refusing them and saying, no, that's not good cause.
Well, the lawyers we consulted say the concept of good cause is very problematic in law. They say it's very complex and problematic, and we have asked them to write guidelines. They say it's the same as in the best interest of justice. They say this concept in law, even though the courts sometimes refer to them, they are very problematic because you can argue around them what good cause means, whether the good cause that somebody has stated is good cause to you or good cause to somebody else. So we have asked for guidance from lawyers, but they warned me that is a very complex area of law, which gives them tough time always in the courts.
So it's likely that that will be an area that, again, could see you caught up in some kind of litigation to say, well, the minister didn't apply his mind properly here in terms of the good cause that I presented.
I suspect so. I suspect that might happen, actually.
And therefore, I mean, in a sense, what is the change then, in practical terms, that you are now proposing in the white paper that could help you deal with that particular challenge?
In the white paper, we are proposing a lot of things, but the two most important is that, number one, the 4 acts of parliament that were enacted after democracy: the Citizenship Act of 1995, the Identification Act of 1997, the Refugee Act of 1998, and the Immigration Act of 2002. They need to be repealed in their entirety, and we start from the beginning. That's where we are going to correct some of these anomalies. More so, the Immigration Act of 2002 and the Refugee Act of 1998, quite often they contradict each other. Like, this is a classical example. The people get arrested via the Immigration Act of 2002, but Section 2 that seems to protect them, as it did in 2018, is under the Refugee Act, is Section 2 of the Refugee Act. So you have got 2 acts of parliament that have got a way of contradicting each other, or it's not very clear exactly how they get harmonized, and we want to make that simple. So the first thing is we are proposing a repealing and starting from the scratch. We are resetting the budget. The second thing we are asking for is the manner in which South Africa entered the international convention. The International Convention, UN Convention of 1951, the Protocol of 1967, and the OAU Convention of 1969, where many countries entered them with reservations, reservation in terms of the conditions in their own countries. And South Africa acceded to them in 1996 without any reservations. And we believe this was a very serious mistake, and we need to correct that. Then the others are important things like who assesses people for this good cause. In other words, who listens to you when you say, I'm applying for asylum because there's trouble in my country. At the moment, the people who do so are called RSDOs, or Refugee Status Determination Officer, who we believe are very junior. I'm not undermining them as human beings. I'm talking about the status of that office. And they have to interpret the 3 international conventions, the 4 legislations from South Africa, PAJA, and the Constitution. quite a number of people won't be able to do that. So we are proposing that rather than have RSDOs at refugee reception centers, we must have refugee boards and refugee appeals board, which are meant by retired judges, senior counsels, and many other people, prominent people, like you can add trade union movement and senior people in government departments who will be able to interpret those laws. And we're also proposing that rather than having refugee reception centers inside the country, they must go to the borders, where at the borders, they assess you and they listen to you immediately. It's either you come in or out. Because once people are already inside the country, it's very difficult to deal with them.
All right, back live. Minister Motsoaledi joining us this evening, Minister of Home Affairs, following that Gauteng High Court judgment. Now, Minister, the international conventions, as they apply here, because I suppose it's also part of what's helping in this particular judgment, the Refugee Act 130 of 1998 with Section 21 and 1B's requirements of showing good cause. Are they only applicable to South Africa, or are we the only ones who did not put exceptions around this particular issue of asylum seekers?
Countries differ, Thabo. I can divide them into three parts, or into three groups rather, not parts. The first group of countries are those who completely refused to enter this convention since 1951 when they were enacted. A good example is India. They are not really part of this convention at all. The second set of countries are those who acceded to the convention, have them ratified by their parliaments, but put in some reservations in terms of Article 42 of the Convention of 1951. The Convention of the UN Convention of 1951 has got 46 articles, but there was a realization that not all the 46 articles will be suitable for all the countries, and they were worried what will happen if a country reads the articles, they want to accede to them and be part of the convention, but there's an article there which they are in disagreement with, or which cannot be applied in their country. So then they introduce Article 42, which gives you a chance to pose some reservations and say, I'm part of this convention, but I'm making a reservation on Article this and that, meaning the Article this and that doesn't bound me. Others are saying, I regard it just as a recommendation, it's not obligatory. So some countries have done that, and the reservations is based on the economic situations of that country and maybe social and other local factors. So unfortunately, remember, South Africa was not a democracy because we were an apartheid state, and United Nations could not allow us to be part of their conventions. So we were only allowed to enter the conventions after 1994. And so this happened. Our accession to the convention happened on the 1st of December in 1996. And unfortunately, at that time, no reservations were posted.
Right.
And time and again, when people challenge us, they do quote that we entered the United Nations conventions without any reservations.
So what needs to happen? What needs to happen now within? I see the court. The judgment is separating separate things for separate of the respondents here. I think another one needs to do something within 15 days. Another one needs to do something within 60 days, and so on and so forth. What needs to happen? Let's just say commonly in the next 60-day period.
Well, is the common cause interviews. That means they are remanded in custody in Modderbee. They are not released, as it was the case in 2018. You don't get an automatic release. The department must try to get good cause reasons from them. So during that 60 days, we'll be investigating the good cause. If somehow we are not able to conclude within 60 days, we must approach a magistrate for extension. And then if the good cause is, we are not satisfied about the good cause, then we can start the process of deporting. But if the good cause is granted, then we have to they have to give them a chance to start applying for asylum. In other words, Section 2 of the Refugee Act will then kick in.
Here's always a very interesting question for you, Minister, and I know you like to talk about it. Are these 6 challenging the state on their own, or are they being assisted here? And do you think they've got a prospect of appealing this particular judgment?
Well, they are being held because there are lawyers involved, and there is always a lot of money for appealing, as far as I know, from NGOs and other organizations inside the country. And I believe they are the ones who are taking these 6. There's no way that will be on their own.
And the other issue is the one which has got to do with visas, right? I see you are being quoted, your department at least, as demanding short-term visitors who have not received visa renewals by 23rd of February, that they must immediately leave the country. And the industry has slammed you on this, saying otherwise these people are called what? Swallows. They are migrants with short-term visas, that you're not giving them at least some 90 days of some sort.
This is very, very unfortunate, Thabo. This was supposed to be an internal memo to guide the newly appointed officers of the BMA at the borders, because they were not there. If you stay in South Africa for and overstay your visas, when you go through the border, you are automatically declared undesirable and you won't come into South Africa for 5 years. And you have got to apply to the minister waiver or set aside that undesirability. It's a longish process. Now, when you apply to extend your visa in the country and you are given a receipt that you have applied, that receipt itself serves as some form of extension until the final response. So because we did have these backlogs, we thought we needed to help the people at the borders so that they don't declare people undesirable. So it was supposed to be an internal memo which is being misunderstood. The second thing, Thabo, which surprises me, I think, yes, I could declare that the memo, the second part of the memo was not necessary at all. It's about people who have already completed their stay in South Africa. Normally, when you come as a visitor, as a tourist, you are given between 30 days and 90 days, right? If those 90 days expires, you can renew for another 90 days, you make 180. The law does not provide for us to extend below, above 180. You have got to leave if you are on a tourist visa. And if you want to apply for any other visa, you would have left. Now, there was no necessity of this circular because it was automatic. People have always left before without being informed. Now the noise is because there's a circular which they see which is informing them to leave. Nobody gets informed to leave because they know it's conditions in their own visa that we have got 90 days or 30 days or 180 days. You don't need any letter, extra letter to inform you that on such and such a day you must leave. It was a very unfortunate thing because they said they were trying to deal with people in the BMA. I believe they should have been cooperating and be informed because the circular is all over. Everybody's interpreting it in whatever way they want.
All right. Let's touch another one on the visa, and then we'll get to a message from one of our viewers. The other one is the Malawi dispensation, 71 countries. Are we part of those 71 countries?
I am not sure of that. I don't want to mislead the audience or the viewers. I'm not sure of that. I need to go and check.
Yeah, because they're saying 79 countries, including those who are in the SADC region. But this no visa is extended to those countries that are also extending a no visa requirements to Malawians coming into the country.
No, all SADC countries, Tawo, don't need any visas to come to South Africa. All SADC countries. So it's not about Malawi, it's about every SADC country, of course, with the exception of DRC. While SADC countries don't need visas from other, most SADC countries, including ourselves, do need visas from residents of DRC. And there are reasons why that is happening. But otherwise, if you are from SADC, you just come to South Africa without a visa. But it means you have got a total of 90 calendar days for that year to come without a visa. But once you exhaust your 90 days, it doesn't mean you must go away. It simply means you are now compelled to apply for a visa.
All right, let's read one of the WhatsApp messages. I think this is, of course, coming from the High Court judgment and how people are interpreting and understanding what this court judgment says. This one is from Thomas saying, good evening, Mr. Mtuli. South Africa needs more people like Dr. Motsoaledi, people who are patriotic and fearless to do what's right for the country. I wish he could have our full support in pursuing good governance. Thanks, Thomas, for the message. Here's one from Anonymous. Ask Minister Motsoaledi, now that he has the law on his side, what is the action plan to deport especially those illegal migrants owning spaza shops that are poisoning our people and take away business opportunities for citizens, and to protect the locals from unfair competition, since these migrants are not paying taxes and compete unfairly against taxpayers and citizens?
In October, I called a meeting of all the district mayors, all the metro mayors, and all the houses of traditional leaders, parliamentary house of traditional leaders in 7 provinces, because Gauteng and Western Cape do not have such a house. We spent 2 days in Beachwood discussing this issue, together with the Minister of Cooperative Governance, Minister of Human Settlement, and Minister of Small Business. Also, there was a Director General of the Department of Trade, Industry and Competition. We did this issue made resolution. The first resolution is that every mayor must go and do an audit of spaza shops in their area. Conduct that audit, therefore give it hand it over so that we assess the owner of that spaza shop. If the owner is legal, of course, we'll start the process of deportation. If he's legal in the country, we'll demand that the spaza shop be registered, because we are insisting that municipalities must start registering spaza shops. And when they register them, they must also register them for tax. We also took a resolution that all traditional leaders must have a register of people within their area of jurisdiction who have entered their area from other countries, because we were surprised by the fact that there are people from other countries who go to a rural area. They don't even go to the traditional leader to ask for permission, which people inside the country do. I come from a rural area. I can't just wake up from my village, go and put out house in another village without going to the traditional leader and asking for space there. And so we think all those things are abnormal and want to take action. Lastly, we asked the Minister of Culture to develop a set of bylaws which will be followed by all municipalities, because some of them didn't understand. How come we are suddenly living in a country where somebody opens a spaza shop without applying for a permit, without registering with SARS and paying tax, and then in that very same spaza shop, the person eats there, cooks there, and eats there, sleeps there, and watches there, whole church service and all that, yet they are selling food in such premises. It's wrong, and we've agreed that this must come to an end. And my worry is whether municipalities are doing that or not, but we have actually informed them over a 2-day period.
All right. Minister, let me take one more question that's come through for you. I hope you'll be able to assist this viewer. Hatabo asked the Minister, I have 2 permits not released. Permanent residents in 2019 applied for work permit renewal in 2022. None of these have been released. Does that mean I am illegal in South Africa?
Well, it depends what brought him to South Africa. And I've already told you that if you have applied and you have got a receipt, that receipt serves as an extension until such time that you get a response from the department, whether they reject you or they don't. And I think you will fall within that particular group. But each case has got its own merit. I would like him to give you details so that we go and check what are the merits of his case.
All right, much appreciated. Minister, thank you very much for coming on this evening. We do appreciate your time. Minister of Home Affairs, Dr. Aaron Motsoaledi.